Okay, everyone, welcome back to the last contract law class for the year. I thought I'd start today. We're going to do revision today, so we're going to answer any questions you might have, talk a bit about the exam preparation, or go over some of the tips and stuff, just to get you all on the same page about that, and we'll go over a question from last year on terms. First of all, though, I just wanted to draw your attention, I'm sure you've seen this, but just to remind you about my availability. I have office hours as normal this week on Friday from 12 till 2 in my office. And then during the exam study period, I will have 3 office hour sessions on those times and those dates. So please, if you do want to come see me, you can turn up. You do not need an appointment. Just turn up at my office during that time and I'll be there and we can discuss any questions you might have. I will answer emails during this time, but please, if you do have questions, I would prefer you to come and see me. And if you email me a question, I might ask you to come and see me if I can't answer it too easily in an email format. But just notice that last line. I will only be answering email questions until the 7th of November. After that, you're on your own. So that's an incentive to get onto your study. So if you do come up with any questions, you'll be able to ask me either during the office hours or or via email up until the 7th of November. Good. And also remind you, we've been through this in class, I won't go through it again, but I would just draw your attention again as you start really focusing on the exams. Do remind yourself of the information that we have told you about the exams. This was posted on the 11th of September in Canvas, so you can go and have a look at that on the announcements. Particularly the format, so that you're not surprised. And particularly about technical issues. Don't have technical issues on the day. So what you need to do is make sure that all the software and stuff you need is downloaded in advance. Do it if you haven't already done so as soon as possible. And also, of course, that the exam is going to be open book. So your notes, open book. Hard copy. Remember that. You will not have access to notes on your laptop. So you need to have hard copy versions of everything that you think is going to be needed in your exam. What I've said before in the past, I still think is a good idea, is to try and synthesize your notes for each topic down to a single page of A4 so that it's then easily available for you to remind yourself during the exam. You won't have time to be studying things or looking up things during the exam. I mean, you obviously will have time, but you won't do very well if you're doing that. If you want to do well, you want to have all the information there at your fingertips. So I would be going through the content that we've done, going through each topic, understanding it, revising it, and then using the information and synthesizing it down into a single page. You can only really do that if you have a clear understanding of the law, and so that is a very valuable way of checking your understanding. And then practice using those notes when you do your previous exams. Treat those previous exam questions as you would an exam question for real. Give yourself the same amount of time as you would in an exam. See how long it takes to transfer the theoretical knowledge that you have or the general knowledge that you have about a topic to the specifics of an exam question. Okay, so that's how I would approach it. The only other thing is I would remind you that you are going to be It's a 2.5 hours exam. You've got 3 questions. You're going to use that 2.5 hours, I think, fully. If, therefore, you get to the end of the time allocated to a particular question, I would strongly recommend that you finish that question immediately and move on to the next one. You are going to get more marks generally by starting a new question than you would in perfecting and finishing off an old one. So please do keep to your allocated time. Finally, if you are running out of time in the exam, make sure that you get as much information as you can down in the time available. So if you do need to use bullet points to finish off an exam, that's fine. If you're running out of time, that's better than not getting all the information down. Please do not write your entire exam in bullet points. I will not look kindly upon that. But if you are running out of time, then that's acceptable at the end there. Something else I was just going to say then. No, it's gone. Are there any questions at all about the exam now that it's less than 3 weeks away, so it's getting a bit closer? All good? Happy? Great, fantastic, sounds great. Okay, I wanted to go through and do some revision now of the topics that I've taught, so frustration, mistake, and terms, and then use the last few minutes to go through question 4 from last year, which is a terms question. But before I do that, I want to ask just any questions. I asked you guys to go away and think of any questions and bring them here if you had any. Are there questions you would like me to address first? And obviously as we go, you can put your hand up and ask me questions as they come to you. But is there anything that you would like me to address straight away as a revision? Your understanding is perfect. That's great. Yes? In the exam? There are questions in the exam. What did we say? They're all problem questions, is the answer. All problem questions. Which means that the application of the law that you know to the facts is the skill that we're looking at. So the identification of issues, the citing of the relevant law, but then the application of that law to the facts and reaching a conclusion on that application is what we're looking for. And as I said before, please do come to a conclusion and please answer the question asked of you. For example, in this question that we'll do later, you're being asked to advise AT, whether it has a defence in contract law against Crouchback's claim and to ignore the Consumer Guarantees Act and the Fair Trading Act. Okay, so please, when you're answering that, please advise AT and advise them whether they have a defence against the claim. Okay, but yeah, all problem questions. Cool. Other questions? No? Okay. What is frustration? What did we do when we looked at frustration? Remember that frustration is a defence against a claim for breach of contract. That one party has not performed their side of the bargain or part of their side of the bargain, and they seek to raise frustration as a defence against a claim for breach. And the argument is that the defendant would be trying to make would be, yes, I failed to perform, but the reason I failed to perform is wholly outside my control, and it would not be just to hold me liable for breach in these circumstances. So it's when you are arguing that you cannot perform, or it would not be just to hold you liable for failing to perform because of a change in circumstances. And this change in circumstance is usually, is often natural causes, but it can also be things like due to human agency. But it cannot be due to the fault or the responsibility of the contractual parties, the outside circumstance. Okay? Has to be a circumstance that's arisen outside the party's control. So we saw in national trawlers, for example, you can't argue frustration when you've been given 2 fishing licenses, and you choose which of the 5 ships you are chartering to grant that license to. You can't then say, well, those ones that I didn't grant a license to, I chose not to. Those charters are frustrated because we don't have a fishing license. Because why do you not have a fishing license? Because you chose not to give them in this instance. You need to show that the circumstances which are outside your control have made performance of the contractual obligations in question radically different from what was contemplated by the parties when they entered into the contract. So you obviously need to look at 3 things. What did the parties contemplate when they entered into the contract? What is the circumstance? And how has that circumstance changed? And to what extent has it changed performance? What will performance be possible? And if it's not, then you're not necessarily going to be successful, but you're obviously a big step further towards to arguing successfully that frustration of the contract, that there was a frustrating event. Often the cases involve, as we say, natural events or big events like fires, or we might have earthquakes or tornadoes or any disasters that you can think of. But remember, it's not the event itself that is frustrating. So just because the alleged frustrating event is something that looks like a frustrating event, like an earthquake or a plague or a tsunami or something, that's not enough to say that it's frustrated the contract. You need to show that performance of the contract is now radically different due to that event. So it's not really the magnitude of the event that's relevant, it's the effect of the event upon the contractual obligations. So, for example, say there is a massive earthquake in Auckland, destroys many, many buildings, perhaps kills many people, disrupts road networks, etc. Well, that looks like a frustrating event. And let's say we had a contract whereby I was to supply you with goods every day, for example. So we had a standing contract. I cannot argue that the earthquake was a frustrating event unless I can show that it has made performance of my obligations to deliver you my goods radically different. So it's not just the event, but it's the impact of the event upon my contractual obligations. So I would need to show that the roads are blocked, the warehouse I stored the goods in has been destroyed, something along those lines which show that I cannot now perform, or performance will be radically different from what we contemplated. And it might be that actually I'm perfectly able to perform as usual because the road to your store is open and I've not been affected in any way, and neither have you. We saw in the Gore Power Company Limited that the change in the value of money is generally not a frustrating circumstance, simply because it's foreseeable to the parties that the value of money changes. Nor is it enough to merely show that the performance of the obligations in question would be more onerous. You need something more than that. You need to show that this was an event that occurred that made change performance radically different from that contemplated by the parties. And in order to show that, you need to think about, well, what did the parties foresee, or what should they have foreseen when they entered into the contract? Because if they foresaw or should have foreseen this event occurring and they didn't provide for it in the contract, then that's good evidence to suggest that they intended that the risk of failing to perform the losses would lie where they fall, and that no one should be excused performance even under these circumstances. And we saw examples of frustrating cases where the contract was frustrated. We saw the destruction of a specific thing in Taylor and Caldwell, which also talked about the death or incapacity of a named person. That could be a frustrating circumstance. Jackson and Union Maritime Insurance, we saw that a delay which made the commercial venture of the parties radically different from what they'd entered into could be a frustrating event. We saw in Fabrosa Spolka an example of a change in law making what was once a legal contract illegal is a good example of a frustrating event. Shipping goods to Poland was legal when we entered into it, but thanks to the outbreak of World War II is no longer legal. And generally these cases render performance or most of the performance of the contract impossible. But not always. We have seen also cases where the courts have said it's frustrated even though performance is perfectly possible, but the reason for performance has been removed. The foundation of the contract has been removed. And that's the coronation case of Crell and Henry is the great example for that. We saw those examples, and then we looked at the leading New Zealand case of Planet Kids from the Supreme Court a few years ago, which adopted and applied this multifactorial approach that Lord Justice Ricks set forth in an English Court of Appeal case called the Sea Angel, which is not a test in the sense that you have to satisfy every element, but it is a way to help formulate and organise the relevant factors or some potential relevant factors that will help you answer the question whether the performance is radically different. So in the Sea Angel multifactorial approach, he talked about among the factors, so it's not an exhaustive list, the terms of the contract itself, its matrix, so what was happening at the time the contract was entered into, the parties' knowledge, expectations, assumptions and contemplations, in particular as to risk at the time of the contract, so what the parties were foreseeing when they entered into the contract, objectively ascertained, the nature of the supervening event, and the reasonable and objectively ascertainable calculations as to the possibilities of future performance. Can you perform under these new circumstances? Don't get too caught up in the Sea Angel multifactorial approach. It's a good way of focusing the mind on what did the parties enter into? What obligations did they assume? What risks did they assume under the contract? What is the event that has made things different, and has it made performance radically different? Those are what those factors are trying to get at. And in all of that, the risk analysis which party bore the risk of the frustrating event occurring, if either, is very, very relevant and important. And if you can show that actually the risk that this event was to occur was clearly on one party, or the parties have thought about it and decided to do nothing, then you won't be able to argue frustration. And we see that in Salam Air, where the shutting down of commercial air travel was a risk that on the terms of the contract and the parties' relationship was clearly meant to fall on the hirer of the planes. And so therefore when it occurred, the hirer had to take the losses. Okay. Hopefully none of that is new, but any questions at all about that? About frustrations, when you would have a frustrating event, why you would argue frustration. Great, okay. And then what's the effect of frustration? It's to remove both parties from having to perform their obligations from the date of the frustrating event, but not before. And sections 60 to 69 of the Contractual Law Act, Contract and Commercial Law Act, beg your pardon, provide for some restitutionary relief for obligations that have been performed prior to the frustrating event. So in short, all money paid or payable prior to the date of the frustrating event must be returned under Section 61, subject to an ability for the court to allow the party who has been paid to keep some of that money if they can show that they have incurred expenses in the performance of the contract. And under Section 63, if one party has performed a valuable benefit prior to the frustrating event, so they haven't given money but they've given services or goods, then the court again in its discretion can grant an award of money to reflect that valuable benefit. Under Section 67, there is provision that the parties' own remedies that they have set out in the contract are to prevail, if any, in the event that there's a frustrating event. And under Section 68, there is the severance provision, which effectively says if you can divide up the contract and take away parts of the contract that have already fully been performed prior to the frustrating event, then the courts can sever that part, treat it as a contract that's been performed, and then only apply the other sections to the part of the contract that has actually been interrupted by the frustrating event. So the way I like to think about this, or a good example of this, is if you have, say, the provision of goods or services every month but it's a long-term contract, but you provide goods and services every month and you pay for them every month, and then halfway through the term of the contract, many months in, there's a frustrating event, brings the contract to an end. It makes sense for the court to say, well, each of those months that have been performed, we can sever and just ignore. They've been performed fully. We don't need to worry about it. We will only apply the provisions relating to frustrated contracts to the month that it's been interrupted in and any future months. Okay, so we don't need to worry about what's happened in the past. We can sever those. But as we've said in classes, don't expect to remove all losses from all parties when you have a frustrating event. Generally, although no one's at fault, one or both parties are going to lose out in some manner. So don't expect the provisions under the CCLA to solve all the problems from a frustrating event. Sometimes that just happens and No one's at fault, but people are going to lose out. So don't be surprised if when you analyse the sections that still people suffer losses. Great. Questions about frustration at all? No? Okay. So, we then looked at mistake. And we looked at how the law treated mistakes by parties prior to entering into the contract before the passage of the New Zealand mistakes legislation. And we saw that there were two divergent views about mistake in common law and equity. In common law, the writing is supreme, is king. You cannot get out of your clearly written contract. It fits in with rules around like the parole evidence rule as well. That's all the same viewpoint informing that as well. So any mistake as to what you're entering into is to be dealt with as a problem of formation, that we did not have a meeting of the minds. But because we take an objective approach to formation, if you sign an agreement that objectively is different from what you thought you were signing, too bad, you're bound. Then we had equity, which has a much more expansive view of the agreement. It's not just the writing, but it's your actual agreement. And equity says that when you enter into a contract, a written document, and you know that doesn't reflect your actual agreement, or you know the other party is mistaken, then it would be unconscionable for you to enforce this written agreement, and the courts of equity will not allow you to do so, and so the other party will be able to get rescission of the contract, which brings the contract to an end. Thanks to the passage of the mistakes legislation now contained in sections 21 to 32 of the CCLA, that pre-existing case law around rescission and formation is done away with. You are to analyse mistakes according to the sections of the statute. You do not need to worry about formation because we assume that there's a contract under sections 23 subsection 4, and under section 22 subsection 1 rescission is no longer able to be argued. However, two pre-existing doctrines relating to mistake are kept: the common law doctrine of non est factum and the equitable doctrine of rectification. And non est factum is a slightly odd doctrine. It doesn't fit in with the normal common law approach to the importance of the writing, where it says that if you have been misled in some way as to the meaning of the written document that you have signed as your contract, you can argue non est factum, that it's not your deed, that you did not consent to this because what you thought you were signing was substantially different from what you actually signed, even though you signed it. So you're going to have to show that it's substantially different, what you signed and what you thought you were signing. And the reason you signed it, despite it being different, was not through any fault of your own, broadly speaking. So you're going to have to really show that you were misled in some way. And if you can do that, then the effect of non est factum is to bring, is to say there was never any contract at all. Which obviously is a drastic remedy, which can have real-world consequences for not only the parties to the contract, but other parties who may have relied upon the existence of the contract. And because of that drastic effect, the courts are very wary of finding non-est factum when it will impact upon third parties. And they will say, well, if we're choosing between who should bear the loss, an innocent third party or you who entered into the contract by mistake, we're going to put the loss on you. And that explains the difference between the cases of Bradley West, where non-est factum was not allowed, and Lanzeal, where it was allowed. We also, under the mistakes legislation, keep the doctrine of rectification, which is an equitable doctrine which grants a discretion to the courts to change the wording of a contractual document in order to reflect the actual bargain that the parties entered into, and then to enforce that rectified document. And we see this in action in the case of Dundee Farms. The basis for rectification is again unconscionability, that it will be unconscionable for you to enforce a written agreement which you know does not reflect the actual agreement that the parties entered into. So in order to show rectification, you have to show that the parties had a mutual agreement and that mutual agreement continued up to the time that they signed the written document, and that written document for some reason does not reflect their actual agreement. Then we also saw that rectification can also be awarded in cases of unilateral mistake, where one party is mistaken as to the effect of the document or what the document contains, and the other party knows it. So there's no mutual mistake there. But the courts of equity would say, well, no, by allowing the other party to sign it when you knew that they were mistaken, you were essentially saying that you agreed by your actions, that you agreed with what they thought the agreement was. Therefore, you're stopped from going back on that, and so therefore we can grant rectification. Now it appears that that has been done away with. Rectification for unilateral mistake has been done away with, at least in New Zealand, according to the Court of Appeal in TriStar. Aside from those two doctrines, you then have the mistakes legislation, which allows relief under Section 28, and that relief is whatever the court thinks is just. It's exceptionally broad discretion. You're not limited in the relief you can apply for, and the courts are not limited in what they can grant. However, to get relief under Section 28, you're going to need to show that you can satisfy the requirements of a qualifying mistake under Section 24. You're going to have to show that either there has been a unilateral mistake that's known to the other party, or that both parties made the same mistake, or that both parties made different mistakes about the same subject matter. You're going to have to show one of those three different types of mistakes. And then you're going to show that also that mistake resulted in a substantially unequal exchange of values. And you're going to have to show that the risk of mistake was not expressly or implicitly placed on the party arguing mistake. Furthermore, Section 25 says you cannot argue mistake if the mistake is the interpretation of the contract itself. Any relief you are granted under Section 28 will be will have to take in, the courts will have to take into account the effect, the way in which, if any, you caused the mistake or you are responsible. And the courts also under Section 21(2)(b) must not exercise their power to grant relief in a way that undermines the security of contractual relationships. And we see in Watson and Zhao quite a restrictive view of the CCLA, I would argue, both in applying the section 21(2)(b), but also in making it clear that the parties must have turned their mind to the thing that they're mistaken about. You cannot be mistaken and you can't be influenced by that mistake if you just didn't think about the thing that turns out to be not as good as you assumed, I suppose, if you didn't think about it. So there, they had not turned their mind specifically to the weather tightness of the home, therefore they can't be mistaken about it. And even if they are mistaken about it, they can't have been influenced by that mistake to enter into the contract because they weren't thinking about it at all. So there is a question as to how broad the CCLA really is, or how much bite it really has. And that was mistake. Any questions at all? Yeah. No? Gosh, you guys are fantastic. You don't have any mistakes. You don't have any questions at all. Okay. You must know it all, which is fantastic. Okay. The last topic we did was terms, obviously. Last year, there was a 30-mark question, so it's about 45 minutes, which was question 4 of last year's exam, which is a terms question. We've got about 15 minutes left. I want you to have a look at question 4. Can you guys read that, or is that too small? Can't read it? Too small. Okay. Let's see if I can make it larger. And the answer is yes, I can. That's great. No, not like that though. Sorry. Let's do something. Okay. Is that any better? Better? Okay. Either read it up on the board or in your on your devices. We're going to give you about 4 minutes to read this, and then another couple of minutes to think about what this question is asking us, what issues arise, and what arguments you will make. Please remember to look first at the question, which is to advise one of the parties, AT, whether they have a defence in contract law against a claim by crouchback. Okay, go to it. 5 minutes, guys, and then we'll come back and discuss. Okay, sounds like you guys got some idea. Okay, so what's Crouchback's claim? What's he suing? Why? What's the claim? Fantastic. Okay, so they're presumably in torts. Okay, so he's got a claim of $1,200, which is the damage caused by one of AT's employees to his property. Okay, so how can AT possibly have a defence in contract law against this? On what basis can AT have a defence? Yeah.
If they've limited their liability.
Yes, if they're limited to their liability via contract, and in fact, according to the plain meaning of this term, which is the only one you're given, they haven't limited their liability, they've excluded it. They said they're not liable for any damage caused to personal property. However, that damage is caused, including willful damage by any AT staff member. So, on the face of it, that clause applies to the damage caused to Crouchback's electric scooter. The question is that clause part of the contract between Crouchback and AT? So, AT, you're advising them, they want this clause as part of the contract so they can rely on it. How are you going to argue, or what's their best argument for this contract, this term being part of the contract? How are they going to get it into the contract, if at all? Yeah. Okay, so what are you So, what sort of cases are you relying on for that argument? What's it analogous to? Yeah? J. Sperling, yep, that's one of them. Yep. Fantastic, yes. And they're known collectively as the ticket cases. The point in this example is that he has not signed a contractual document with this term in it, so you can't argue Lestrange and Gracob. It's not an oral term which is incorporated into the contract because the parties have had a conversation about it. So you can't rely on those J. Evans cases. It's instead a ticket case where you're going to have to rely on some other manner to incorporate it in, and you're going to argue that he has gone on the train many times and never complained about it, so therefore by his actions, just like in the ticket cases, he has agreed to this term. Okay. What is AT going to have to show to say that this term is incorporated into our contract with Crouchback? Yes, over there. Fantastic. Okay, so that he was given sufficient notice such that he has an opportunity to refuse the terms. And remember, there was those three different scenarios that were discussed in Parker. If he doesn't know there's any writing on the ticket in Parker, then he's not bound. If he does know there's writing and he knows that they are contractual terms, he's bound whether he reads them or not. If he knows that there's writing but doesn't know that they're contractual terms, he is bound if the railway company has given sufficient notice or made it clear that a reasonable person would know that these are contractual terms. So, in this instance, we know that Crouchback hasn't read the online terms. He's dimly aware of seeing the signs on the train, but he's never taken much notice of them. So he's aware that there's writing, but it appears that he doesn't realise that it's meant to affect the contractual relationship. So the question is, has AT done enough to bring it to his attention? Yes?
I have a question in terms of because the ticket or the cards are technically electronic, so it's all done online, and the fact that the terms were online, is there any sort of connection that you can bring up with that?
So we're not told how he bought the ticket nor how he topped it up. But yes, you would have to, either way you'd have to show that there was some sort of notice given. And there could be an argument to say actually he had notice at the time he bought the ticket and or topped it up, but we don't know. But that would be a relevant fact that we might want to know. So you could just say, look, that would be interesting to know, because that might be another avenue for AT to argue that the term has been incorporated. However, because we don't know, we can't go any further with that, or something like that. But that's excellent. If there is a fact in the exam that you don't know but you think would be relevant, please say that. Say what you want to know and why you think it's relevant, how it would help you answer the question. Just like that. Perfect. So we don't know. All we've got to go on is that he's got the ticket, he jumps on board the train, and there's a sign which is legible but small in light blue lettering which says all passengers agree to ride in our trains in accordance with our terms of services online. So it's a factual analysis, and you'd have to say, well, is that reasonable notice, particularly when the sign doesn't actually contain the terms of services but they're online, so he has to go onto his phone to look at them.
And the sign's on the inside, presumably.
Mm-hmm.
Because they didn't put the sign on the outside of the door, so you tag,
Yes.
accept the contract,
Yes.
walk in and agree. It's analogous to that case with the chair.
Yes. So, fantastic. So there's two problems that AT are going to have to get over. Firstly, was reasonable notice given? And so you're going to look at how they directed their attention to these terms and services, but also you would have to discuss the Sperling discussion around the more onerous the term, the more notice must be given to it. And there's a good argument to be made that this term is exceptionally onerous. You can have AT employees deliberately destroying your stuff and you can't sue them. And they've buried it in section 37.1.5e among 56 terms and services on the website. I think you could make a strong argument that that was not reasonable notice for the seriousness of the term. But also you have the problem that the term came too late. However, there is a difference with the Chappleton case and a difference with the Thornton case. What's the big difference here?
He's been a user for 3 years.
Fantastic. So he's had multiple opportunities to read this clause. You'd have to argue a consistent course of dealing according to Hollier and Rambler. And I think on the number of times he's come on, you could argue there's a consistent course of dealing, assuming they haven't changed their terms and conditions, but I don't think they have. Not aware on the case, on the facts. But also then the question still becomes, when he came on those earlier times, was sufficient notice given? So fantastic. That's what you'd have to discuss. You'd have to say, it's too late. If this was his first time on the train, he wouldn't be bound. But it's not his first time on the train. He's been on it many hundreds of times. He'd be bound. Look at Hollier and Rambler. Look at the cases it refers to. So quantity of times he could say consistent course of dealing if if there's sufficient notice given, and there's a big question mark over that. And then, we didn't talk about it in my section, but then I also wanted you guys, when you read this, to interpret the exclusion clause. The fact that it is a very broad exclusion clause. The courts generally approach exclusion clauses with hostility. And then that's 30 marks. So generally, I think the answer would be he's probably not bound. But some people did very well arguing the other way. Okay, everyone. Terms, we've done the exam question from last year. Of course, we also did implication and interpretation, but we haven't got onto that. So you'll just have to study it yourself. Good luck for your exams. Do not stress. Put the work in now. And I say this every year and everyone hates me for it, but I hope you all get the mark you deserve. Thanks, everyone. Have a great time.